Welcome to episode 59 of Tangled Rights. Yeah, that's
Hi.
right number. I thought I was reading the wrong one. We are your hosts. We are at the Cox & Wilson Law Firm, as you can see behind me. I'm Shane Cox. This is Justin Wilson. We're both attorneys in Las Vegas.
Yep.
Justin also practices in Kansas, and we are seeking
100%
entry.
winning record as a criminal defense attorney in Kansas.
Seeking entry into other states as well.
Oh,
On the
yeah.
prosecution side and on the defense side, right? So
Yeah.
we're gonna try to get admitted to other states.
We're
maybe,
doing great.
Maybe when you hear that here, we'll actually be admitted in other states. Who knows? It just opened up that you can get admitted to other states. We are two attorneys in Las Vegas. We are not intending to create a legal relationship with what we're saying. We're just commenting on some things, usually criminal law cases that are in the news, kind of illustrating for our purposes, kind of filling in the gaps of some of these criminal cases you might have heard of.
Things you might not know about.
Things you might not know about, the why. There's always these questions people not studied in the law about, like, well, why is that?
Yeah.
There's a lot of presumptions. A lot of people are quick to judge. That's just how we are as a
Most
society.
people, all people.
We are quick to judge, and then we need more details. So there's reasons why judges act in a certain way. There's reasons why prosecutors act in a certain way. And then when you can disagree with them, maybe
100%.
more fully. But
Well, I mean, the thing is that more information is always better than less information. And in this instance, I think what we're talking about is the information of understanding the structure behind these cases and also some of the stuff that people probably aren't seeing. That's the thing I think a lot of lay people forget about, is that there's shit that's going on underneath this stuff that's going on underneath the surface that you don't think about. And when you look at it, you're like, oh, how could that have happened? Well, there's 10 other things that you don't know about,
right.
that the jury didn't find out about, so they're not going to publicize.
But on some of these public trials, you do see some of the motions argued.
Sure.
People typically only tune into like the big headlines, like the attention grabbing stuff that you can then talk about with somebody else. Like,
What was her name?
Watching.
Fallow Daybell.
We're going to talk about her in a second. Yeah. She had another trial. So quickly, I want to elicit a point with this. Okay. So Lori Vallow Daybell had another trial in front of the same judge that she just had her previous trial in, which is kind of abnormal, because they're separate charges. These are being tried separately. I don't know if they're charged together and then separated out. Obviously, it's a new jury that comes in and judges her. So this was an attempt murder. Basically, it hired her brother who had passed away to shoot at her niece's husband, who she had thought was possessed. For those who don't remember Lori Vallow Daybell or hearing about it for the first time, she thought she was some kind of prophet or married to her husband who was a prophet. Kind of like a doomsdayer kind of thing.
Every word that you were saying there, I expected to be like the end.
Yeah.
And then more shit just kept.
There's
like what?
She's been.
But the question I have, was he dead when she tried to hire him, or was he?
Oh, no.
Okay, 'cause the way you worded it, I was like, that's not a crime, bro.
I mean, this some people know this full story, so it's like I'm glazing over it here.
Got it.
She had her ex-husband killed by her brother. Okay, convicted recently of that, saying that it was in self-defense, but it wasn't. Her brother eventually died. His last name's Cox too, so I'm not related as far as I know. But her brother eventually does die of a heart issue. Okay, so he can't be a witness in any of these cases. She marries a new guy, the prophet kind of guy. Then her two children pass away and die. His ex-wife dies as well.
Right.
So there's just a string of deaths here. And then this last one is the only one where the alleged purported victim is not dead. He gets shot at, doesn't even really know he's shot at, like kind of hears it, but it's not a good attempt. Yeah. It's not a good attempt.
Squeak.
But regardless, this trial is much like all of her other trials. She has standby counsel for it. She gets kicked out of court. Okay.
In her own trial?
In her own trial. Yeah. It's like on a break, the judge kicks her out. So we want to clip in this. I want to compare this. So Justin, we'll have you watch this while we clip this in. Okay. I have the link here.
All right, please be seated. The jury is no longer present. We've concluded that sidebar. A record's been made. I would just caution the defendant again. She needs to be very careful, and she's getting into areas that could open a huge door that I don't think she wants open. I'm going to make another record at 1024 to 1025. We held a sidebar that I don't think made it onto the court record. That sidebar again discussed similar issues of if the defendant brings in evidence or testimony that she was a good person and no ill intent and those sorts of things, and specific acts of her being a good person, it could open the door to other things that she may not want the door open to. The state, the defendant, and advisory counsel were at the bench when we had that short 1 minute sidebar, but I don't know if anyone wants to supplement the record on that. Ms. Kay?
Just, Your Honor, that again, the state did raise any issue of character evidence under 404A and 405, that if the defendant opens the door and tries to advise that she is a good person, a peaceful person, a kind person, a loving person, any of those other types of things, that we believe that would allow us under 405 to then bring in specific acts such as the murder of her children, her husband, and her current husband's wife.
All right.
Which would also be 404B that they withdrew.
No, it would be 405.
Yeah, they withdrew it, but if you bring up 404 that you...
Then all 404B is in, or do we get a hearing on what 404B can come in? If I open the door, do I get a hearing? We stop trial and I get a hearing on...
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could include being convicted of 4 murders. So
and would you
talk
like...
to your advisory counsel during the break. And
you don't need to yell at me either.
I'm at you, okay?
Yeah, you are, and you do not need to talk to me that way. I'm very courteous.
Take her out.
I'm very courteous to you.
Take her out. No, you have been nothing near courteous to me during the course of these proceedings. Talk with your advisory counsel about the rest of your cross. We're going to resume in 15 minutes.
All rise.
So, okay.
Well, we'll talk a little. I want to parlay this with Ronnie O'Neill. You probably remember Ronnie O'Neill. And I think it was a pretty light thing for her to get kicked out of court, but they were at the end of the hearing anyway. She's being held in custody while she's coming out. So they, out of the presence of the jury, they take her into like her little special room, and then she comes out dressed normal. We've talked a lot about how they, have to look innocent. Okay, or not guilty anyway.
Well, of course she's guilty. Look, she's wearing the orange.
Yeah,
obviously
exactly.
She did it.
Exactly. So I want to parlay that with this other one that you've probably seen before, of just this great closing argument of another pro se defendant, Ronnie O'Neill.
Mr. O'Neill, you need to speak audibly so that the jury can hear what you're saying.
Yes, ma'am, I haven't begun yet. I was talking to my father. He showed you a fraudulent recording where they allege that I beat Kenyatta Barron to death. He talked about Mr. Khalil Brown, my neighbor who stayed across the street. But if Mr. Khalil Brown was a help to them proving me guilty beyond a reasonable doubt, they would have called Mr. Khalil Brown. But I called Mr. Khalil Brown to be a witness for me. And I didn't ask him to lie about one thing that he saw that night. I asked him to tell the jury exactly what he saw that night. And you have to ask yourself why that is. because he's playing a fraudulent damn recording of me beating Kenyatta Barron 15 damn times when that did not happen. And like I told you earlier, you will know the truth, whether in this trial or the next one. Better believe it. If you think I'm here to play around with y'all, God damn it, I'm not.
All right, Mr. O'Neill, please stop using swearing language. It's not appropriate in a closing argument.
Now, he played a recording that was sped up. Why didn't you play the regular recording that people can understand what the call was saying?
Objection to the defendant asking me questions, Your Honor.
I'm going to sustain
I'm talking to
okay.
people.
Mr. O'Neill, listen, please just keep in mind this is not personal towards the prosecutors. Please keep your comments directed towards the evidence and the law. Thank you.
Yeah. All these objections now. I know for a fact Kenyatta Barron's recording from her phone did not record calls sped up like that.
I'm going to object now. He's talking about facts, not in evidence of what he knows.
Again, ladies and gentlemen of the jury, as you were instructed, the closing arguments are just that. They're not the evidence or the instruction on the law. It's just what the parties believe the evidence shows or does not show. All right? Thank you.
You heard Mr. Khalil Brown. You've been hearing me for 2 weeks now telling you that they committed criminal acts against me with the 911 calls and that fraudulent video that they just showed y'all. Now, I'm going to prove it to you. You heard Khalil Brown. He said that he was actually sure that I only hit Kenyatta Barron 3 times. You heard it. I called him to tell you that. I ain't running from nothing. They didn't call Khalil Brown to tell you that. I did. You have to ask yourself why that is. Because I want you to know the actual facts. I did kill Kenyatta Barron. But I want you to tell it like it is if you're going to tell it.
God damn it, I'm not. You know, that makes me think of Trailer Park Boys. There's an episode where Ricky asks to defend himself, and he's talking, and it's actually the way he words it is very funny. He's like, he stands up, he goes, well, Your Honor, first off, I haven't had a cigarette in like 10 hours, and I'm about to snap. Also, I only got my grade 10, so I don't know all these big people words. And if I can't smoke and swear, I'm not going to be able to express myself appropriately. And in a way that, you know, I'm going to be prejudiced by this. And the judge is like, I'm going to allow it. Ricky, you may smoke and swear. And so then he walks over to the prosecutor. He goes, let's go, smokes right now. He goes, I only got 2 left. He's like, I don't give a fuck. You've been a dick all day. And he gives him 2 cigarettes, and then he gets to smoke, and he gets acquitted.
What a great TV show. Not much like real life a lot of times.
No,
So,
but what I was going to say about the second guy is yelling doesn't mean that you're making your point better. If it did, I would win every argument I ever have. But I don't, so I don't yell all the time.
But you've won every trial, so that's with tact, though.
But I haven't yelled.
Well, and then
I do things, though. I have little things that I do. Like one of my favorite things to do in cross-examination is with someone when they start just, I'll turn around and start walking away from them, look at the jury, and just like, hey.
Are you allowed to do that?
Yeah, I do whatever the fuck I want. Sorry, comma ESQ. And it's that nonverbal communication. I'm communicating with them saying, garbage.
they're making up stuff.
They're making up stuff. Or I ask a question and they're not even answering it. That's not the first. You don't do that initially. You lock them into their answer, or you say, hey, I understand you want You want to explain? You're going to get a chance to do that on redirect. But my question's a lot more simple. What I asked was this. Can you answer it, please? And they'll just start, man, and you just walk away.
And there's a jury instruction for Ronnie O'Neill specifically about not letting emotions kind of take over. You have to, think logically.
Don't let your emotions.
Yeah. So it really does say there's a jury instructions that we do have that say not emotions. This is about facts and logic.
We are a nation of laws, not of men.
Sure.
Or something, which I've never understood.
And I like to overlay those because Lori Vallow Daybell was kind of calm, but
there's history.
In this prior trial, they had this same argument about it's not a statute here, but 404B, 404.3, 405.
That's like federal. That's the same as the federal, though.
But it's the same rules we have.
Right,
Prior bad
character.
acts, character witness stuff, character testimony. So she knows from the prior trials, you can't talk about how you're a good person because then we have evidence that you're not a good person because you've been convicted of these crimes beyond a reasonable doubt.
Murder.
So she said that the judge raised his voice. He really hadn't raised his voice. And so she gets kicked out, but not really, but it's kind of an interesting little clip. And then you have O'Neill yelling at the jury and staring daggers at the prosecution.
He does have a very intense stare. I remember that. But when I watch that, it makes me, I don't get uncomfortable by it. I want to make a, slow jerk motion.
He's not, it's not.
You're not
He's
helping.
not doing anything in front of the jury. He's not helping himself at all.
No.
I want to talk about a few things out of these clips. Opening the door. They talk about opening the door.
Yep.
Okay, what does that mean, Justin?
It's essentially exactly what it is, what it sounds like. You're opening a door. What happens once you open a door? You can walk through it, right? So if I open a door, you can go through it. And in this situation,
if you open a door for yourself, that means it's open for someone else.
Open. So if I say, my client is a great person, you certainly get to rebut that or refute it. And if there's evidence to show that my client's not a great person, like the other 6 times he was accused of the same thing and convicted 4 of them, 10 years before or whatever, stuff that you normally wouldn't be able to bring in, you can bring it in. You can do it on other issues too. There's lots of random things that can happen. But essentially it's, I say something and I'm leaving it hanging that normally someone would counter and then they get the opportunity to counter. Whereas if I hadn't said anything, they wouldn't just get to bring it up on their own. Because that would be inappropriate. It would be prejudicial, whatever.
Yeah, there's certain things outlined, and prosecutors know this about prior bad acts.
I used to think prosecutors understood evidence. But
maybe they do and they disrespect it. But prior bad acts and prior crimes normally can't come in unless for specific purposes.
Mimic.
Yeah.
Motive, intent, mistake.
Okay. All right. Are you going to look them up? Or
I'm
what?
Googling it right now. Give me a second. You know what I'm talking about,
Motive,
right?
intent, mistake, identity, or common scheme or plan.
Yeah.
Okay. All right. So usually these don't come in. Prosecutors know this. This is like one of those that most of the times the judge don't even have to tell them, hey, you can't ask this question. This could cause a mistrial. Every prosecutor should know this. So unless the defendant goes up and gets on the stand or elicits testimony from other people about something specific, then they want to prove something like, hey, I'm actually a good person, instead of talking about the facts of the case and hey, you can't prove this against me. All your facts are bad. Use my cross-examination for this. So she wants to open the door. She wants to talk about how good of a person she is and not have them bring up these other things.
Of course.
So the judge has had this conversation with her a million times. I think that's why he's just annoyed with her
it's
at
just
this
that
point.
there's history, right? You got this person and she's like, well, I was respectful to you. You weren't respectful to me. But he knows every time she's been a jerk to him during the trial. And it's like, well, lady, you didn't say anything now, but you've said it 50 other times. And we've also discussed this 20 times.
Yeah. Another thing I want to point out that came up in this trial is she had standby counsel. They called it something else. Advisory counsel, kind of the same thing.
Conflict counsel, whatever.
Conflict counsel is kind of different, right? But
I'm trying to remember what we call it. I think in standby counsel is what we call it.
We call it standby counsel here, as far as I know. It's an attorney that's sitting by for a pro se, a person that believes that they want to be pro se, that hasn't quite lost their right to counsel. Like we've seen some people have lost their right to counsel.
But they're gonna.
so they can still talk to that attorney, and the attorney's still getting paid by the state to be there, but they're supposed to still do everything by themselves. It's just kind of like let's preserve these issues for appeal kind of thing, just to help you out as much as we can. There was an issue about standby counsel coming up to the bench because they didn't have enough headsets, because they didn't want Lori going up to the bench because, she's a convicted murderer, and for the safety of the judge or whatever, even though she's a small female and
presumably doesn't have a weapon.
He's up above on the bench, and he seems like he's a pretty tall, athletic guy. But regardless, they were doing all of their sidebars on these headphones, and there were not enough for the standby counsel. So, and he was kind of frustrated with her already with that. It's like, you've chosen to go pro se. So you're trying to have your cake and eat it too, kind of thing, where you're trying to be pro se, but yet have an attorney.
And who doesn't want that?
I mean, yes, like, why would you have a cake and not want to eat it too, right? Like,
I have both.
Usually
I have one.
Usually that's how it goes.
I cannot have one, in fact, without the other.
Yeah, I wouldn't want my cake and have blow out the candles and then just me not eat it. Like, that would be.
What if you don't have cake and you didn't want it, but then you have to eat it? Like, someone just comes up and you have to eat their cake. This fool, he's had that happen.
Austin will eat any cake whatsoever.
Austin, come get on camera and show him what I'm talking about.
So standby counsel is just that. They're standby, okay?
They stand by.
It's just an emergency if you choose to waive that self-representation and actually have a trained attorney help you out in your case.
The one question I've always had with that is, what happens if in the middle they're like, oh, I should let them go. All right, you're in. Tag.
And so
what happens?
Here in Nevada, and I would guess in most states, the judge has broad discretion. That's how a lot of things turn out, is the judge in
almost
the case
they're in charge
has
or something.
Broad discretion to decide.
Whoa.
And unless they have a really bad error, it's going to be what the judge says. So you have an absolute right to counsel under these Bill of Rights that we have, these amendments to the Constitution, which are,
we love them. Love those rights.
Pretty tough to waive your right to counsel. So I would guess they'd say, all right, have the counsel step in, but warning you, they're stepping in and you are not self-representing after this, because there is a whole test here about a person who wants to represent themselves. The judge has to ask them a number of questions to make sure that they understand the decision they're making. Because what we see in a lot of cases is a defendant will choose something and they'll accept something and say that they want it and then get a punishment, and then afterwards say, I didn't quite understand, I didn't know what was going on. So the higher level courts have told these trial judges, no, you have to ask them all sorts of questions. You have to go through this, especially in high level cases like a murder charge, or attempt murder. That's huge too. You got to canvass them, ask them questions. What do you know about the law? Have you ever done a cross-examination? Have you watched it before? Have you worked at a law firm? Have you studied the law?
Do you know how to admit evidence? Do you know how to object?
Yeah. And so most of these people have no idea, but they still have a right to represent themselves.
I object
with that standby counsel.
To you.
No surprise, Lori Vallow Daybell was convicted yet again.
For the fifth time?
It's fine. This was a little bit ago, but
0-5. Time to give it up.
Yeah.
Crime is not for you.
She was already doing life.
Now she's going to do life again. What they're going to do, and I don't know if you guys know this.
She's going to be reborn?
No. Well, if you are, you go right back into prison. But what they do after you die, they just leave you in the cell. Decomp in there, you fall apart, and they just leave you in there for another, however long your life was. You have to do that again. But yeah, some poor SOBs in there with your decomposing body.
They'll send the corpse from Idaho to Arizona or whatever.
100%. Yeah.
I've never understood.
So if she lives to be 80, she's got to spend 80 more years.
Does the state have I
made all that
Are
up.
they fighting over which prison to put her in? Now she's convicted in Idaho and Arizona.
So I think it would probably go to the first one.
First one? I would
guess.
Because
first in time is, at least when you're dealing with concurrent and consecutive sentencing, that's the way it works, right? Let's say she got 10 years in each one. She'd do first and then she'd go second. So I think it's the first one. But in that situation, when they know she's going to do life anyway, I'd be like, take her. You can pay for it. I don't care.
Yeah, Idaho has where she killed her children, so that's that's an egregious crime.
I'd want her.
I mean,
And we can keep her bones.
I mean,
Dude,
whatever.
here's a weird
She has
question.
a vision. She's going to be with her husband out of prison again. So.
Okay, well, see what the Lord does for her.
Yeah.
Although the world might end any day now.
Yeah, we got that going on in the background.
I deleted on my social media.
We're never
never
going
gonna
to see
see
Grand
GTA
Theft Auto 6, huh? Yeah.
Did you see that picture of the skies over Iran? And it shows, and there's one plane, and it was like UAE 729, and it said the rest of the world, and it shows them staying away from Iran, and then it says UAE 729, Leroy Jenkins is just flying straight over.
I'm going to talk about another murder. Do you have a joke or no? Okay, we'll talk about another murder. Have you heard about the Karen Reed case at all?
I think so. Give me some facts. I remember them based on facts, so not names.
I'm not an expert on this. This trial was just happening for the second time. First time a year and a half ago or something like that was a hung jury. So it ended in a mistrial. Instead of pleading it out, it went back to trial. Okay. So Karen Reed, this is in Massachusetts area, in the Boston area. She's never married, never has any kids. She's in her 40s or 50s.
No kids, not married, 40s or 50s?
Yeah. She works in finance. So she admittedly says, she's not like that. She has a boyfriend. Okay. The boyfriend comes into play here. She just doesn't want to do the family route.
That wasn't going to be on camera. It would have been a me and you thing. Like he can swap.
I understand, but I'm for our purposes. Okay.
Perfect. Now everyone else is too.
For our purposes, she's just.
She has a boyfriend.
Are these new age women? I don't know what we call these. Like,
I mean,
maybe feminist,
I don't know. It's just like a personal choice.
It is her personal choice.
If you didn't want to have kids,
if I wouldn't have had any, I guess, right?
Yeah,
so
like,
Karen Reed just is a finance bro girl, I guess. I don't know, something like that. Works in the finance industry.
So she's like Sam Altman-Fried.
Sure. So she is on trial for second-degree murder of her boyfriend, who she is having fights with. He is found dead in the winter, in the snow.
Is it the one with the ATF, or like there's feds involved and she drove him there, but then there's other guys that killed him?
No, I don't know what you're talking about. No, he's a cop. He's a cop, though.
Well, it was cops. And she took him someplace.
They were at the bar.
I'm thinking of a different one.
They're at the bar. She's accused of being, no, this is not the suitcase murder. She's accused of being DUI and intentionally running him over with her car and fleeing the scene. Okay. The facts and mysteries around his death are super interesting and weird. There is a big toss up in everybody watching this, whether or not she's actually guilty of this crime.
Karen Reed. This is the one I was thinking of. Because there's a bunch of other cops involved.
There's other cops, not feds though.
Okay, well.
I don't think there's any feds at all.
I don't know.
But they were all at the bar, yes.
Yeah, but then she takes him to like a house or something. They're there. There's a bunch of weird text messages. And
yes, there's text messages.
The cops maybe did it.
The cops could have done it, yeah. Nothing about feds though. The cops. Yes, so this is an extremely weird case. It's on for trial now the second time, okay?
This is saying, well, go ahead.
She's found not guilty the second trial.
I was going to say.
Yeah. So the trial just ended this week. She's found not guilty on the big charge of second-degree murder,
and manslaughter,
anything under the murder umbrella, but is found guilty of driving under the influence. Okay,
so she gets a misdemeanor,
which is
who cares?
A misdemeanor offense. Yeah, they don't have proof that she's actually the one. And the way they did it is super weird on the DUI. They didn't test her blood until the next day, so they used kind of an impairment theory and like backtrack what her blood would have been.
How would you even
the day
know?
before? Because she admitted to driving. Okay,
she must have been hammered for still to have alcohol the day later.
Yeah, and the range that the expert gave was like 0.13 to 0.27, so a huge range, which is kind of weird in and of itself. But
so she's also, I'm sorry, I'm just reading something.
No, go ahead.
She's the family's going to sue her.
Yes,
and the two bars where they drank.
I'm sure there will be a civil suit. I guess they don't have a dram shop law like we do here anyway. So, and we've seen that before. The famous O.J. Simpson case. You can be acquitted or found not guilty of a murder or of any crime, but still be civilly liable. because there are.
Why is it easier to convict him?
It never breaks down to a percentage. Sometimes as defense attorneys, we want to talk about percentages. In civil law, they allow us to
There
say
is a percent in civil.
just over 50%. So it could be 50.000001 as long as there's
Perfectly
a one.
balanced. One feather.
Yeah, we
Preponderance.
use that example. So just more likely than not that these elements are met. Whereas in criminal, it's beyond a reasonable doubt. And sometimes as criminal lawyers, we want to equate that to the highest percent. You know, you have to believe 99.999. But normally courts don't allow that. Normally courts don't allow that. Maybe 80 to 85.
If I was going to actually put in a percentage, but I wouldn't say that.
We're normally not allowed to.
But
right?
you can make it. You can illustrate it with a point that makes it seem like it's even higher.
Okay, what's your illustration though?
So
to help with that?
Someone gets kidnapped, right? And I'm a prosecutor. I'm saying it's not beyond all doubt. It's beyond a reasonable doubt. I'm going to give you an example of what an unreasonable doubt is. An unreasonable doubt would be if I said little green men came down from Mars and took this person and put them over there. You could make the burden seem so high by giving an illustration of what an unreasonable doubt would be. That's just absurd. Everything else underneath that seems then like a possibility that could convict them. And that's not a percentage, but like if you're putting it on a continuum of 1 to 100, right? Wouldn't that be pretty crazy? That puts you in the 99% range, the 95% range. Although it is possible that there are aliens, not the kind that come from other countries, but like from other planets.
Sure.
Right? Doesn't that seem way out there? So it would be a higher percentage. You see what I'm saying? Or am I not wording this right? I didn't think about this before I said it, but I'm just kind of
we're spitballing here.
That's what I would
podcasts are, right? I heard not a joke, but like just an illustration of one time of a defense attorney who goes up on a murder case without a found body that says the victim is about to walk through that door. Have you heard this before? Victim's about to walk through that door. Let's just watch. And everybody turns and looks. And then the defense attorney says, I know he didn't, but you had some doubt, didn't you? You had some reasonable doubt. And then the jury turns back a guilty verdict. And they say, well, why did you turn back a guilty verdict? And they said, well, everybody looked except for your client. He never looked. So just a dumb little story. Right? I don't think any of it's real.
You better pre-plan him and tell him, hey, look, when I say this, you're going to turn and look at the door. But that proves a point. The jury is always watching her.
Yeah, they are.
And I don't know if that's true or not, but
yeah. So
hold on.
What I want to talk about there was so much trial in this. There's like a month's worth of trial. A lot of people were watching because each trial went about 2 weeks. And there's a battle of experts here because the guy who passed away had like some marks on his body. And there was an argument as to whether those are from being hit by a car or being attacked by a dog or getting beat up with something else. So there's kind of a battle of experts in this case. His injuries and cause of death are at issue as well. Like every single fact here was at issue. So I wanted to talk a little bit about experts and expert witnesses because people were watching expert witnesses and kind of have questions about who can be an expert. Like we could talk about your thing, but
I just thought of something when we were talking about looking or whatever. There's an attorney. His name was Clement Vallandigham, Vallandigham, sorry. And he was an attorney, and he was representing a guy who'd got into a bar brawl. And the claim was that the guy that got in the bar brawl shot the guy he was fighting with. But the attorney was trying to explain how the gun could have been pulled out of the victim's pocket and accidentally gone off.
Yeah.
And he shoots himself while he's demonstrating to the jury and dies.
Sheesh.
But then the guy gets acquitted because he accidentally shot himself while he was drawing his pistol from his pocket while rising from a kneeling position. He said he would demonstrate it to the jury. He thought the pistol was unloaded. Alec Baldwin. God wills it. Although he was fatally wounded, his demonstration proved his point, and the defendant, Thomas McGeehan, was acquitted and released from custody. only to be shot to death 4 years later in a saloon. But I don't know. That the idea that like demonstrating and something crazy happened and just brought that. It's weird, but it's funny.
I mean, accidentally shooting yourself is
No, that's not funny. I'm just saying like
insane.
if we're talking at like the Dadaism, like absurdity of it, it's like, oh, I'm going to demonstrate this.
that can't be planned. Hopefully, I don't know.
Probably
But,
not. Whatever. All right, let's get to your
I do want to talk about experts, the Dalbert standard. Okay.
Dalbert.
This is a 1993 U.S. Supreme Court decision. This kind of created the framework for the admissibility of experts in cases. Because you can have experts on all sorts of things. I think we talked about that before. If they can actually assist the jury in understanding something and whether what they're talking about is something that can be tested. It's not just like an opinion-based thing.
Correct.
That there can be like a rate. Oh, here's the standards. There's a known or potential error rate. And then some kind of standards in this operation and whether there is widespread acceptance within a relevant scientific community.
And then also peer review and publication.
Peer review and publication, yes, is a big part of that. So it has to be something scientific, in nature under this Dalbert standard. So all of these people that come to testify for both the prosecution and the defense, because there's experts on all sides, have some kind of training, but they're paid thousands of dollars to give an opinion, and they're hired for a specific reason. We've done criminal cases don't seem to have as many expert opinions as civil cases, I think. Just depends on the kind of case.
Yeah, if you're talking like a SA case, which is sex assault, where you're dealing with DNA and stuff, or murder, same kind of thing. You've got ballistics, you've got all kinds of stuff. Then I think you're going to end up with a bunch.
The bigger cases in both, I guess, are more likely to have experts.
Right. But then the real thing I think that's important to highlight here is, when do you need an expert? Regardless, whether it's criminal or civil. That's the important thing. I understand the standard is great.
You have to have some kind of issue and dispute that an expert could illustrate, right? And help understand. Right. Cause of death,
it can't be a basic thing. It has to be a technical.
It has to be technical.
Or, something that a normal person wouldn't understand.
Right. So, cause of death in this specific case is very disputed. Shards of a vehicle being left at the scene was a big part of it too. Okay, so what he was hit by and what pieces of the vehicle were left at the scene?
Like
was it
chunks of
a brake light? Yeah, pieces of a brake light. Okay, so he's supposedly hit by a brake light. So
I guess I could kill you, but talking just the corner of the vehicle, you don't get run over.
It depends on the speed, right?
Yeah,
and that's the dispute. He was kind of left out there and left for dead in the cold.
So that brings up an interesting point. You don't have to kill somebody outright to get charged with their murder.
No, not at all.
Because the law in most places says that if you hurt someone and you can render aid, you have a duty at that point if you didn't have a duty before, right? If I put you in a bad position, I have to get you out of it. But if I'm walking down the street and I see Austin bleeding out, I don't have to help him. Now, if I throw, a hammer over the building and then I go out and I'm like, oh shit, I hit Austin in the head with that on accident, then I have to help him. That kind of thing.
Yeah. Yes. So,
although I said on accidentally.
If you do
on
that.
accident or accidentally, one or the other, they don't go together.
And the defense position was always that Karen was not even at the scene. She didn't hit him. It wasn't her car.
Was her brake light damaged?
I don't know about that. And I needed to watch this a little bit more because I was very, very tangentially watching this.
I'm sure if it wasn't, you'd know. Because they'd have probably made a big deal about that.
Or getting her car fixed that always seems to come up in cases, of somebody that hit somebody with their car, they get their car fixed at the right time or get their car washed right at the right time or something like that to get rid of evidence. It's like, no, I just have a monthly car wash pass and I happen to go that day. And it was just some red paint that, they were getting off my car.
Yes.
So,
you got a spot of red on you.
What I do want to talk about that in this case specifically is cross-examination. Cross-examination, some people seem to hate when they're watching this. Why is cross-examination even a thing? Like, why does it exist? I'm going to give a quote John Henry Wigmore, he's a famous attorney back in time here, says that cross-examination is the greatest legal engine ever invented for the discovery of truth. Okay, which I think is a great quote. I think we've seen that. I don't know in your last trial if your co-counsel used that quote or a different quote about cross-examination, but it is so incredibly easy to go up and tell a prepared, rote story and kind of just go through with your attorney that you can talk to ahead of time about what you're going to talk about, and kind of like you can even have a script prepared with your attorney. Okay. Question, answer. This is what and your attorney, since there's an attorney-client privilege, can give you this script and say, this is exactly how I'm going to answer the question. The attorney can even go up and have their script and read the question word for word. And you can say yes, or you can tell, your story. But where the rubber meets the road in cases is having that other attorney who you kind of know what they're going to ask.
But you don't.
And you can try and prepare a client for this cross-examination, because this is where kind of the real heat comes. Okay. And we've talked to quite a few juries on this, and the juries are ready for cross-examination. They anticipate that it's going to be kind of heated. So you're not going to make a jury too upset by coming after somebody, because that is exactly what they expect. So some attorneys are a little too soft on this. Some go maybe too hard. Like there's this sweet spot in the middle of cross-examination where you're friendly but persistent,
Well, there's also a lot of intangibles, right? Like
there's a million. Yeah.
Like with child victim or with child witnesses or whatever. As a man, I can't do things that a woman can do sometimes, or else it's going to come off different. And conversely, sometimes women, like there's that whole deal where I can't remember if it's women that judge women more harshly.
Yes.
But like if a woman goes a certain way, they'll view her as bitchy, whereas a guy can do it and he's assertive. And it's all these random things that society has created for people. And there's a couple of quotes that I tried to remember just a minute, and I looked them up because I couldn't remember. One of mine is, the art of cross-examination is not the art of examining crossly. It's the art of leading the witness through a line of propositions he agrees to.
Until, what's the end of that quote? There's an end of that quote that's awesome.
I don't remember.
Okay.
What is it?
I'll have to look it up now. Okay.
Oh, wait. Until he is forced to agree to the one fatal question.
Until he's, forced to agree to the one fatal question. And there's different kind of cross-examination strategies. There's Trojan horse. You've heard of that one, right? Where you kind of plant something there that you're going to expose later. You're going to.
Well, and that's a beauty. Like I never called it the Trojan horse, but I really like it because you get the jury where you can tell they want to know the answer to the question, and then you leave that thing out there and they're fixated on it. So especially if it's a hook or a cross, as far as putting it into a punch analogy, where you're really slamming them with it. So they're salivating looking for this information. Then when you finally give it to them, it lands even harder. And I like that. What was the other thing? I don't remember. I get good ideas and then I forget.
Hey, that's just like being up there and cross-examining someone.
Dude, I love cross. I love cross. My favorite part.
It's incredibly fun. You have to be bold. You have to be persistent. Like I think you're
unafraid.
Unafraid. You like to do those things.
Oh, I remember what I was going to say. So the reason cross-examination is important is the same way that like whenever we're doing a Valdez-Jimenez hearing, which in the state of Nevada is for bail on people, like that one we just had in Henderson.
Yes.
The prosecution conveniently left out, because she's arguing the facts, like why the bail should be monetary. She left out the fact that my guy had wounds on his face that indicate that maybe the other person is telling the wrong story.
For domestic battery.
Yeah. That's exactly why cross-examination is important, because they're not going to put they should. If they're smart, they're going to put the bad facts up and explain why they don't really matter.
Sure.
But most of the time what they do is they put the good stuff up. And if you didn't have cross-examination, you wouldn't get to hear the other side of the story.
Yeah.
And that's why cross-examination is important, is because as an advocate, like our job is to zealously advocate for our position, which doesn't include telling untruths or omitting facts if you're a prosecutor. But sometimes it seems like they do, and that's why we've got to do it.
There's a lot of, we talk about psychological studies because these come into play a lot in trials, because you're talking to just like, an average person. It's supposed to be the average person. Mm. So we talk about these psychological studies. Typically a story that a person hears first is going to be the one that they believe. So we're kind of at a disservice being on the defense, because you're going to hear the prosecution side first. Mm. but balance that with the prosecution has to prove their case beyond a reasonable doubt. So they do have that high bar, 80%.
If you can get the jury
Yeah.
actually.
So you have to get the jury ready to hear things and listen kind of a different perspective. And sometimes we think that we get like hits in with cross-examination, like, hey, they're saying something that doesn't align. Like,
But they don't care because they've already checked out.
They might have already checked out, and you're the bad defense attorney, and they might have painted your person already as the evil or bad person. Okay, so it's kind of it's tough. Cross examination is super important, and you think like, let's get to it already. Like, hey, they've said their thing, but if you say your thing and you're left unchecked, then it's super easy. Like where you really see whether somebody's honest or not, I think it's through, having another person ask you really about the details. And then sometimes it starts to unravel and you'll see a little like something there that they're trying to cover up. Or a person might introduce evidence that opens the door to something else, like we talked about earlier. So in watching these cases, we appreciate listening to the cross-examination because there is so much preparation that goes into maybe one or two specific questions. And attorneys can sometimes leave it at one or two specific questions to show.
That's really all you want. You do the whole cross-examination.
Yeah. And there's so much preparation that goes into it. And I think Lori Vallow-Daybell talked about how difficult cross-examination was. That was the hardest part,
especially
of her case. To a non-lawyer, because you have to be so ready and listening and just like, you have to know your evidence ahead of time. You have to know exactly where it is. And then while you're listening to testimony, you have to be locked in. Like typically you'll have a team of attorneys and you'll have one watching the jury. You want to watch the jury politely and not like staring at them.
I'm not supposed to have my mouth.
You're not supposed like you typically do. You'll have one,
dude, no wonder they don't like me.
Subtly watching them because they're looking over there.
Sure.
So you are glancing because the defense table is usually by the jury box. Yeah. Okay. So, and that's by design.
So don't breathe hard.
There's a lot of things that can bother them. So you want to have one.
Come here. Put your creepy sex face on camera.
No, please
don't. Make that face again, though, so Shane can see.
I didn't see it. I don't want to see that ever again.
No, me neither.
So you have one subtly watching the jury. You have another attorney watching the box. We call it the box when you put the witness stand.
Yeah, the witness box.
The witness stand. So you have a team, and the attorney that's watching the witness is getting ready for cross-examination, taking notes, and might even up to the very moment of asking questions be altering or amending. Language and how things are worded as a question is super important because we're kind of talking off the cuff. I go back and listen to us talk all the time. We kind of misspeak and say things wrong.
Say stupid shit.
We say stupid stuff, but we say it differently than what's in my brain. Like I hear myself say things and like, that's not what was in my brain at the moment.
Not what I meant.
So preparation is so important.
Sure is what I said. Though.
Maybe specifically how to ask a question. And we'll go back and forth and say, hey, should I ask it this way or some alternate way? So we talk about, even specifically how you'll word a question to elicit an answer or to show the judge, it's a good question, how we're asking it. The second part of this quote of the John Henry Wigmore I was talking about, that it's the greatest legal engine ever invented for the discovery of truth. He does bring a caveat to that. A lawyer can do anything with cross-examination. He may, it is true, do more than he ought to do. He may make the truth appear like falsehood. Because of cross-examination's power to distort the truth, Wigmore recognized the need for it to be controlled. So there can be people that get up on a stand and are completely honest and get confused about facts. I've seen it time and time again. Like I see something on video and then I see somebody testify to it and they get just confuse themselves. Okay. They just confuse themselves. They answer something one way, and memories are so imperfect. They're incredibly imperfect, and people conflate things in their mind. So a great attorney can even get somebody to say something that they might not even believe in cross-examination.
You can trick them up.
So.
And that's the thing. You don't want to seem like you're trying to purposely trip up on words or like worry about semantic differences unless that's important. But my trial coach, and I always kind of look back to my training on the trial teams because I do truly think that the training I received and then the training in the DA's offices were basically the same. Completely different places, completely different schools of thought, but like the underpinning of it was all the same. And you look at like $1, $5, $10, and $20 questions. Cross-examination, you're looking for that $10 question. And the way that my trial team coach worded it was, you're walking down the sidewalk in a gloomy area, it's dark, and there's $1 right in front of you. You're going to bend over and pick it up. There's a $5 bill on the edge of the sidewalk. You're going to pick it up. There's a $10 bill just a ways off. It's not quite in the bushes, but it's worth going and getting. That $20 bill, it might be great, but there also could be something waiting for you in the bushes, right? It's all the way off over by the tree. And the idea is, I'm going to ask a question that's dangerous, right? It could work out for me. It could be great, but also the opposite could be true and I get smoked. So you're looking for those $10 questions to really hammer your points home, but you're not going so far that you're setting it up to have your point get undercut or this witness to rout you and get the best of you.
And most witnesses were not allowed to, interview them or ask them any questions until maybe the time of trial.
Yeah.
Unless there's a preliminary hearing.
You can interview anybody if they want to talk to you.
If they want to, well, certain people, you're not going to be able to, right? Like the cops, the police, who are a lot of the big witnesses.
Call them if you want.
You can call them. Are they going to answer and talk to you?
No, but you can try.
Okay. I'm just saying
I don't think there's a rule against that, is there?
It's the first opportunity to try and that you're actually going to be able to speak to them is at trial, right?
Sure, because they're actually not going to speak. Yeah. I've had several cops who I saw, it's like, oh, we got prelim. You want to talk to me beforehand? And they're like, no. I'm like, okay, that's fine.
Yeah.
They
are independent witnesses. They're not represented by the state. The victim is kind of always, or purported victims are always kind of protected. That's kind of a big no-no, but they have to have something in a police report. So you kind of go off that a lot of times, or body-worn camera footage. You can bring that up because those are prior statements by a witness that, are very important to a case.
Correct.
But a lot of it is you don't know what they're going to say.
No.
And on the prosecution side, a defendant is never going to talk to the cops before, he's never going to talk to the cops after kind of the initial encounter. Sometimes they say too much, but then once prosecution starts, once a case starts,
usually not.
The defendant's not going to be talking to the prosecution until he chooses or chooses not to step up to testify at trial.
What they will do, though, is make a lot of stupid jail phone calls where they say a ton of really dumb shit.
We've had too many issues with that recently.
Yeah.
So if you're listening to this and you're in jail for a specific crime, don't call the purported victim. Don't talk to your mom and say anything about the crime.
That was the dumbest one.
Don't talk to your girlfriend and say anything about the crime.
This kid's charged with stalking. The allegation was that he called this girl 155 times in like an 8-hour period or whatever. Basically just like, young person.
Young love.
Doing the dumb breakup stuff, which, man, I thought calling somebody like, okay, it went to voicemail, I'm going to call right back because it's going to override the do not disturb. I thought that made me seem like a crazy girl. 155 times, bro.
Wow.
There's going to be someone else.
That's a big accusation.
Anyway, this dumb shit. He called her from the jail while he's awaiting arraignment to say sorry.
No.
No, he didn't. He says he didn't do that.
Don't do any of that.
But the other thing is, like, I'm sitting there and I'm getting ready to make my arguments for him to get bail or to get like OR'd, and it's like, bro, if they know about this, I'm cooked. You're cooked.
Yeah,
I'm cooked because I'm going to lose, but you're the one who's going to stay in custody, not me. I'm going to go home.
Okay,
hang out with my kid.
Listener question.
Pet my dog.
Listener question. I think it brings us all together of what we've been talking about today.
Can I pet that dog?
This is from Big L Dog. Why are lawyers allowed to do things other than stand there at the podium presenting the evidence?
Oh, you're talking like move freely about the well?
That is the question.
Well, it depends. If you're in federal court, you can't. So,
why the difference? Why the difference?
Because federal court is full of pomp and circumstance, and we only just recently got rid of our wigs and our capes. So.
Don't allow cameras in. Is that public access to justice? I don't know.
Yeah, it is. I personally think that it's not an oratory competition. It's explaining a story. And I think that part of communication is the nonverbal stuff.
100%.
Or a big part of it, right? Yep, exactly. Well, I'm never going to do this. Well, there might be a situation where I'd go, this is what you're doing. This is what I want you to do.
Kooky. Like,
Listen, fuck them. Don't listen to that guy. He's a tool.
you get in trouble for something like that. You get in trouble for something
I don't know
like
why
that.
that's what I did. Mr. Cox is going to be so disappointed
Some
in me.
facial expressions judges can make comments on
100%.
sometimes too. Like,
Dude, I was in court on a civil case, and this idiot judge ruled on something, and I was like, that's the opposite of what the law says. And so I'm writing down his ruling, and I sighed. And he stops me, Mr. Wilson. And I'm like, yes, Your Honor. He goes, did you just sigh at my ruling? And I was like, oh, did I? Knowing very well that I did, but I was like, oh, sometimes I guess I do that involuntarily. If I did, it didn't mean anything. Proceed. What you gonna do, bitch? You ain't gonna do shit.
judges can hold you in contempt, so I would.
Oh, contempt.
Okay.
Put me in jail. Been there before. Whatever. You want your marshals to look at me naked? That sounds a bit weird. If that's what you want, let's go. I got more tattoos. You're gonna see them today.
Oh, sheesh. Okay,
Hey.
so lawyers are allowed to do this because
We're human, and that's how we
we're
talk.
human. That's how how people respond. If you're up there just telling a story and not able to move,
My name
The
is
jury-
Justin.
the jury
I'm a
is-
lawyer. I'm here to explain something to you. How weird is that? Like, even if we did that at the podcast, you've seen those podcasts where people just.
we
And
were like
then
that in the beginning, I think, too,
in
right?
1290, I was never like that. In 1291, the Moors invaded, and everyone was sad. Right? That's boring. No one wants to hear that story. It's a stupid story.
Yeah, so it's more fun. I think it
Yeah.
elicits a story better.
You definitely get a better response.
Tends to more credibility and more personability.
It's more engaging, and the jury's already bored to death.
Yeah.
Dude, I don't know how many times we've started, and we're just through voir dire, and there's already people over there like,
Falling asleep.
it's like I've been in trial and been like, are we about to have to tell on juror number 6? Because
He's falling asleep.
motherfucker's asleep right now.
Yeah.
Like, is that what I'm gonna have to do?
Yeah, he's an alternate. Yeah, who cares?
He's a narcoleptic liar.
I don't know about that. But hey, thanks for listening to another episode of Tangled Rights. We'll be here. We'll continue recording for you, our listeners. Send us topics.
This contains
Send us body cam.
no added flame retardant chemicals.
Send us questions.
You'll catch on fire if you're sitting in this.
All right. Peace.